All right, good afternoon, everyone, and welcome to today's webinar. My name is Jorge Acosta Palmer, and I'm the director of the Statewide Training Initiative with Florida Legal Services. We're excited to have you join us here today for the first session of our Consumer and Disaster Law webinar series. This one is Mortgage Basics for Assisting Homeowners After a Natural Disaster. Before I introduce our speakers, I do want to go through some quick housekeeping announcements. This training is being recorded. You're going to receive a copy of this recording via email from Zoom within 24 hours. We'll also be posting it on YouTube. If for whatever reason you miss any of these emails, I'm going to drop my email into the chat as well in case there's anything that you need. The training was approved by the Florida Bar for 1.5 General CLE Credits. I'll announce the CLE code towards the end of the session. I will also drop it into the chat, and I will also include it in the email, and it will also be included in the YouTube description. Closed captions are enabled for anybody who needs them. If you're having any issues with accessibility or captions, just let me know via chat or email me, and I'll do what I can to have that addressed. And this training is being co-hosted in partnership with the Public Interest Law Section, PILS, and the Disaster Umbrella Group, Doug. If you're not familiar with PILS, I encourage you to visit their website. I'm gonna drop the link here into the chat. This kind of came through with, we were discussing these topics with the Consumer and Tenant Work Group, and we connected with Kathy and the Disaster Umbrella Group, and we started designing these series. So I'm going to drop the link to the Public Interest Law section into the chat as well. But I also wanted to have Kathy talk a little bit about the Disaster Umbrella Group. So Kathy, the floor is yours for the Disaster Umbrella Group.
Hey, thank you, Jorge. As he said, I'm Kathy Grunwald at Legal Services of North Florida, and I host the Disaster Umbrella Group meetings every month. We meet the fourth Monday of every month at 3 o'clock Eastern Time. If you're not a member of Doug, the Disaster Umbrella Group, then please go to Florida Advocate, that's fladvocate.org, and join the Disaster Umbrella Group there and the Disaster Listserv. You're going to notice you can do it right now, and then within the next month, that whole website is being updated. So it'll look a little different, but I encourage you to go and join that. You'll get the regular updates, which during hurricane season are daily, especially if we've had a storm. So I'll look forward to some of y'all joining, or all of you, if you're not already a member, joining soon. Thank you, Jorge.
Thanks, Kathy. All right, final piece of housekeeping and announcements. Questions. If you have any questions during the presentation, feel free to use the Q&A feature. If the question is related to the topic that we're discussing, I'll probably interrupt Steve and Lynn to let them know that there's a question and we can address it. If for whatever reason we don't address your question immediately, we'll do our best to make sure all of the questions are addressed towards the end. So with that last housekeeping item, I want to go ahead and introduce our speakers for today. We have with us Steve Sharpe. He's the senior attorney with the National Consumer Law Center, NCLC. Steve is a senior attorney at NCLC focusing on foreclosures and mortgage lending. He leads NCLC's federal mortgage servicing policy work and frequently presents on mortgage servicing and other housing issues. Steve is a co-author of NCLC's Mortgage Servicing and Loan Modifications, Home Foreclosures, To Them High, How Junk Fees Add to Skyrocketing Rents, and the report How GSE Note Sales Undermine Home Ownership, which examines the impact of both sales of hundreds of thousands of home loans to investors. Steve testified in front of Congress on the state of the U.S. Department of Veteran Affairs Home Loan Guarantee Program, and he is also a contributing author of the legal treatise Truth in Lending. Steve is a cohort member of the Shriver Center's Racial Justice Institute and former consumer fellow with the American Bar Association's Consumer Financial Services Committee. Previously, he represented homeowners at the Legal Aid Society of Southwest Ohio, LLC, and he started his career in 2005 at Indiana Legal Services with a Skadden Fellowship focused on representing borrowers with predatory loans. I know how busy Steve is, so we are really grateful for having him here today to present to us. And our other speaker, we've seen Lynn multiple times. We're always really grateful for Lynn to come in and share her expertise. Lynn is the senior trial attorney with JALA, Jacksonville Area Legal Aid. Lynn is a consumer protection attorney with over 3 decades of experience at JALA. She represents consumers in individual and class actions and advocates for legislative reforms on issues such as debt collection, payday loans, home improvement, basic transactions, military lending, automobile title loans, and mortgage litigation. I'm gonna drop Lynn's bio and the materials as well. You've seen me work with Lynn. I'm gonna say Lynn doesn't know this, but I think Lynn is my best friend right now at Legal Aid. Like we have meetings about so many topics. She's amazing. So I don't want to take much more time from our speakers. So with that said, I'm gonna pass it over to Steve and Lynn. The floor is yours.
Well, thank you. It is an absolute pleasure. It is very wonderful to talk with you all. Very wonderful to be here with Lynn, and just happy to walk through some things. So we're going to talk about very basic steps and what you need to know to help people with mortgages when they are facing disaster. So what we're talking about is for people who probably want to pay, but the circumstances around the disaster have made it so they are struggling to make mortgage payments, and what you need to understand to help advocate for those people. While I have it up, I'm gonna also put in the chat a link to our natural disasters landing page. We have in our digital library many books, we cover a lot of topics, but one thing we do cover in depth is representing homeowners in the context of natural disasters. That is in our mortgage servicing book. If you have any questions about books, you can always email me after. And in fact, that's the other thing I'm going to put in the chat is my email so that you all have it. Because in addition to the books, and the material in the books and in our landing page for natural disasters, we're also here to help folks who are advocating on behalf of homeowners and help you walk through some of these things. So if that might be the biggest takeaway, we don't represent homeowners directly in these cases, but what we do is provide some technical guidance for folks in the field. That's my email. That's the easiest way to reach me. And I am happy to talk to you about your cases. I'm a former legal services attorney, so I know how hard this is. It is way easier for me to spend 15, 20 minutes with you talking about your cases than to have them myself. Really appreciate what you all are doing. So Lynn, do you have anything you want to say just as a quick opening before we dive in?
No, but thank you. We all really appreciate your being here. And we also really appreciate Jorge for keeping us so informed. The amount of opportunities we have has been amazing. And Steve, you're just proof of that. Thank you.
All right. Well, thank you, Lynn. And let's dive in. So, okay, there we go. So here's our agenda. We're going to cover some relevant rules that apply. And I'm going to say this like 3 times, the key to truly helping someone with their mortgage issue in a natural disaster or anytime, honestly, is to know what rules apply. Who is calling the shots? If you take away anything from this presentation, understanding that and that relief options are different depending on different loan types, if you could take that away and apply that, you are way ahead of the curve here. It is frustrating because people think if they, especially in a disaster situation where we're having something that can affect an entire neighborhood, it is hard for people to understand that maybe their neighbor is offered something slightly different than they are. That is probably hard to understand, but it really has to do with different rules apply to different loans. And as advocates, if you can make that your first step and help the borrower understand that, that is going to put people ahead of the curve, and you will be doing important work for them. Then we're going to talk in very basic ways about the types of options that are available to people. What is different about mortgages than maybe some other areas is that there are options available generally for people when they fall behind that do not have to do with litigation leverage. There are options for relief built in to many, not all, but many mortgages that people have. Now, none of this is necessarily guaranteed. And in fact, part of the challenge is how to get things for people that maybe they should have received and what happens when they don't, because probably don't have to tell anyone on here that it's not guaranteed. Even when there are options available, it's not as though borrowers can just access them with no problem and the system is smooth. It is a challenging environment to operate in. It is especially challenging in a disaster situation. So again, because of that, it's hard. What we're talking about are people who really can't make their mortgage payment because of the situation. That is a different topic of whether they should. The fact is, because things are not guaranteed, probably people really need to try, but we are dealing with situations where that is simply not possible. And what can we do about that, and how can we help them? So, rules, options that are generally available for many mortgages, not out of litigation, but because they are facing, because they have a mortgage and some of these things are built in. Talk about some disaster specific wrinkles, maybe get into some troubleshooting. That is our agenda for today. Again, I'm happy to take questions as they come. And we have a lot of material, like I said, in our mortgage servicing book, chapter 12 of mortgage servicing, in our landing page, some of the other material. And again, I can help you walk through those things, but let's dive in. So, what do I mean by what rules apply? The rules that state what options borrowers should be eligible to receive, what things are built in, are determined at what we call an investor level. When we talk about investors, we really mean who is calling the shot, who is the entity that kind of holds the risk of the mortgage, who would really own it. We are not going to get into the very diffuse structure of American mortgages where, for those of you who were in doing these cases in the financial crisis, mortgages can be cut up and sold in securities. We know that that is a very, to try to carve out how mortgages are held is a very complicated structure. We're not going to get into that fully, but we are going to touch on it in that you have to identify, when you help people, who is calling the shot and whether any of these potential players are involved, whether it is owned or guaranteed by Fannie Mae and Freddie Mac. And if that's the owner of your loan, that is the majority of loans, or at least the largest owner of loans in the United States are Fannie Mae and Freddie Mac. We call them the government-sponsored enterprises, the GSEs. Or if it is insured by the Federal Housing Administration, FHA, meaning FHA, in order to prompt the loan to be made, insured the loan against loss. Well, if they are insuring the loan against loss, they're the ones who say how the options should be going forward. So you may have FHA. USDA, and I mean United States Department of Agriculture, also or guarantees loans kind of in that same structure, and actually has a direct loan program, which we'll get into, and the Department of Veteran Affairs does as well. So those are the federally backed entities. Those are the majority of loans have those in the country, have those as the investor. And those all have not only ways for you to tell whether they're involved, but also rules that apply. So we sort of divide the world between those entities and then private entities, which is a smaller portion of the mortgage market. Those are loans that are owned either by banks, sort of that very traditional way that we probably, if you grew up or you think about how lending is done, you make a loan, you have the loan, you hold it. Private banks still do that and keep the loans on their books, but then there aren't other easily accessible and easy to see rules that apply. That's where it gets hard. And the same goes for if loans are not held by just a lender, but are cut up into pieces and sold in investment through and held in trust. That's another type of loan, also private, because there's none of these federally backed entities involved. And when it's that, also gets challenging to know what applies. So again, mortgage rules and what apply truly depend on these investors, and the world is generally divided between federally backed investors, where we can figure out if they're involved and also see, for the most part, what would apply, and private loans where it is more opaque. Thankfully, for ease, most loans in the country are in one of these federally backed buckets, but we will still deal with private lenders. So if there's nothing else to take away, understanding that distinction and these buckets are probably the most important thing to help people. It is, when you call me or email me, the very first thing I am going to ask you if you want to consult is, who's the relevant investor? Every time. I probably say hi and how you doing, a few things. I may not jump right to the chase quite that hard, but that is going to be right up there. So let's get in a little bit. So this is pretty much just says what I say. So identifying the investors is crucial. Restrictions also come up. I'd say investor restrictions are typically a reason people are told they can't have help. So knowing what the investor are and what the rules are typically are there, because in my experience, often the word investor restrictions is thrown around when it shouldn't apply because the rules aren't such. But that's just the flip side of what we were talking about before. Now, one thing to note here is, and we're going to talk about this in a bit, if it is truly private and in a pool, the restriction, it becomes very hard to figure out what restrictions and what rules apply. And the trust, the investors, the people who bought into the trust aren't really like calling shots. Instead, there are typically rules built into the investment vehicle, and then it is up to the servicer, and we're going to talk about who a servicer is, to figure out what rules apply. It is easier when it is federal because, for the most part, we can, as advocates, go and look at what those restrictions are. So again, the divide is between a private and federal loan in this case. So, like we said, the biggest government-sponsored enterprises, and that is based on their kind of very specific structure and how they grew up, are Fannie Mae, Federal National Mortgage Association, and Freddie Mac, Federal Home Loan Mortgage Corporation. They are, for now, regulated at the federal level by the Federal Housing Finance Agency. Annoying that we have FHFA and FHA, but you know, that's just the world of acronyms. So when it's FHFA, they are the ones that oversee Fannie Mae and Freddie Mac, who own or insure most of the loans in the United States, or are the biggest owner and insure or guarantor of those loans. they were placed in conservatorship, meaning they are now specifically regulated by FHFA. What is also important to know is that because they are so big and are the sort of main player, generally what they come up with, Fannie Mae and Freddie Mac, really can serve as the industry standard because of their big influence. So often entities will have baked into their models concepts that are like what Fannie Mae and Freddie Mac. Sometimes you can even argue if there's nothing available, that those could be sort of the standard industry standard. Those can be hard, and again, it can get challenging when you're actually trying to litigate and enforcing. Specifically, if you have questions about whether they're government actors with due process, give me that is a fraught space, and you can, if you're thinking about those lines, give me an email. But generally, they are considered the standard bearers for the mortgage servicing industry. They are supposed to be, and generally are, aligned. So Fannie Mae and Freddie Mac are different entities, but through the conservatorship, for the most part, they have policies that vary very little. And so it can be very important just to understand what Fannie Mae and Freddie Mac are doing. And for the most part, this is the first place I look. So we're dealing in practicalities here. One of the very first things you can do is, if you have a loan, you're with your borrower, it is not immediately, they don't know. And for the most part, it's very hard for borrowers to know what type of loan they have. The very first thing you can do is go on these loan lookup tools, and you can just pop them in. There are, you can search by their name. You need the last 4 digits of their social security number and their authority to search. So often if someone's sitting there, you can just pop it into your computer and it will pop up Fannie, Freddie, and see if under Fannie and Freddie's records, it shows that they are owned. And that is often one of the very first steps you can do just to know if that's available. So look at these websites first. There is a big caveat here, and that is what once is may not always be. Loans are sold out of investor pools, and that has been meaning they can be converted from federal loans to private loans based on the company's own risk management. So you may see a loan that you looked up and it says Fannie, and then later on, the servicer is telling you no. I'm here to say that that may be something that happens. And if you are dealing with note sales, which are these bulk sales out of Fannie or Freddie, let me know. This can be a challenging space. It's increasing, but not in very, very common. So in other words, it's not like every loan is sold out of pools, but it can happen. And so it's just a caveat that you may have to sort of be fluid in your understanding, and let me know if you see note sale issues. But for the most part, you're going to look up and you're going to decide, you're going to kind of have your strategy based on if it's a Fannie Mae or Freddie Mac loan as your first option. But what if it's not? There are the 3 other entities that guarantee loans. How do you determine that? Is typically the easiest to determine, or can be pretty easy to determine. You can look on the note itself or the mortgage itself. It will often have a FHA case number. On an FHA loan, generally, if there is insurance attached to it, the borrower is making payments into an FHA fund. and you can see that. And sometimes there are other language in the document that would tell you that if it's an FHA insured loan. And so these are loans made by companies. FHA doesn't make loans. Fannie and Freddie don't make loans. These are loans made by private company that have these as investor. In FHA, there is an insurance contract, an FHA insurance that applies, and that is why the rules, they dictate the rules. So again, it might be, you're not going to see generally the loan be from FHA. You're going to see it as a loan made by someone else, but you're looking for if that insurance contract is there. And those are your tells. Does it have an FHA case number on something? Is there language? Is there in the monthly statement a clear statement that they're making a payment into MIP, FHA MIP? And often your borrower will know if they made an FHA insured loan. That one can be pretty straightforward. And again, there are some note sales issues there, though not as many lately. Veterans Affairs Administration, VA, very generally, it's pretty clear. Usually it's in big, bold type on the note and mortgage. There is not monthly payments made, but in the closing documents, there will be a payment to VA. And typically, very typically, the veteran borrower knows if they have a VA loan, but usually it's pretty clear from the documents as well. There's a lot of language in there. So VA is pretty clear. Now, USDA. This is not just farms, though some people operate under that. And in fact, you will hear from VA, used to be called the Farm Home Loan. But these are not farms. These are a program like FHA where there's a guarantee on a private loan in order to encourage borrowing in rural areas. And so the problem here is that in the guaranteed side, it is quite hard to determine. There are some items in the loan docs. You may see some reference to it. Often, if it looks like a loan that has pretty similar terms to FHA, you may think about whether this is a USDA guaranteed loan. You can ask the servicer. If the servicer ever says it's a farm loan and you think, well, my borrower is not on a farm, they must be crazy. It may be because it is a USDA guaranteed loan. I don't have a very good way of knowing it. It just may take some hunting around, and definitely let me know if this is something you're struggling with. Lastly, there is a direct loan program for very low income borrowers from the USDA. This is the most prominent program of where there is actual federal government lending money to the borrower, and they make payments to the United States of America. It's a small-ish program, but it does overwhelmingly serve borrowers who are very low income. So it's there. Borrowers definitely know if they have a USDA direct loan, they make payments to the United States of America. This can be a very challenging program to deal with. And so some of the things that I'm going to say about options available actually don't apply to USDA direct loan, but there are lots of us who are interested in how that program is going. So you can always give us a call. So that is the world and how to determine it. And again, making this determination is really, really critical. I'm going to stop and see if there's any questions. Jorge, is there any questions yet for me?
I don't see any questions posted for now.
Okay. So then in the private space, trying to figure out what applies is hard. You can look at pooling and servicing agreements when you see a loan that is clearly, and you can tell typically from the caption, whether a loan is going to be in one of these private entities, if it's held in trust. And you can try to track down the prospectus, which can include the pooling and servicing agreement, and which can provide information on what the investor structure thinks should happen when a loan falls behind. And like it says in here, the PSA can say who institutes foreclosure, set out guidelines for modifying loans. This is hard, and we do have some troubleshooting in our books about how to do this, but you can sort of search for the prospectus, look for the pooling and servicing agreement, and that is often the best way in these loans that are held in private trust. It is, though, just challenging. And then I should say, I don't have it here, you know, if it is like held by a private bank, a local bank, community bank, you can just ask. People generally do know if they have a loan. You know, sometimes people get loans from their local bank branch that then turn in to Fannie Mae and Freddie Mac loans. Those loans are sold into the Fannie and Freddie pools. And so just because they went to a branch and got a loan from that branch does not mean that branch is holding their loan. In fact, that loan may be, and often is, an FHA loan or a Fannie Mae loan or a Freddie Mac loan. So you can't just say that's it and there's none of that stuff. You go through that process. But in some cases, those branches or those banks do just hold on to their loans. And in that case, if it's at the bank and that's the branch, you just can ask the branch, what are the options here? It's a little bit of a less clear process for what you can see, but can have some advantages. Okay. And so that really then ties into this other key word that we throw around a lot, but that is really, really important. And that is who are servicers. So the servicer is generally who the borrower thinks of as their lender. They're the one who make payments to, and servicing often is done at a national level by big non-bank servicers, but it can be done by banks. It can be done in a lot of different ways. But servicer is different than investor. My servicer, to be clear, may have loans that are FHA loans, Fannie Mae loans, Freddie Mac loans, all of those different types of investor status, and they will look up and need to know what type of loan they're dealing with, because they generally don't set the policy, but they apply the investor rule. So they pass on to the trust, whether that is one of these private trusts or whether it's one of the ones that are related to Fannie Mae and Freddie Mac. Their compensation is very complicated and not what we need to get into, because they are compensated not in a clearly straightforward way. Borrowers don't generally hire and fire the servicer. Often you get a loan and then your servicing is transferred to an entity. And again, that entity is not just dealing with one type of loan for the most part. And so that's where it gets hard, because you got the same servicer as your neighbor gets this option, and you call up and you're like, I want that. But again, that's where it all depends on investor. So what do they do? They're the agent for the owner of the loan. They collect monthly payments. They hold the money in escrow to pay property taxes and homeowners insurance. They send statements, and they're the ones, even though they're not the ones who set the rules, they're the ones that the borrower interacts with in dealing when they are behind on their loan. So that's the key concept here that is somewhat challenging. They are the agent, the one who deals with the borrower. The borrower doesn't apply through FHA for their option. They apply through the mortgage servicer, who then should look at what type of loan this is and then applies it. So it applies the options that are available. So that's where things get tricky, and that is just a really important concept from a basic standard to understand. So again, this is just, just another, summarize it again, just some of the rules that apply and how they are. Here's another bit of this information. So we've talked about who are the kind of key players, and unfortunately, the environment is even more complicated than that, where unfortunately, we also have things like subservicers who take out particular types of loans from servicers. We have vendors, we have other third parties. It is a little more complicated than the picture I have provided you, but from a basic standpoint, key to understand difference between the person, the entity that calls the shots, and the entity that takes the payment and applies the rules that are involved, investor, servicer. Now, what are these rules? What are we talking about here? And so the phrase that is used most is loss mitigation. And if you have experience in this, you've heard this a lot. Loss mitigation, mitigating a loss that applies when someone unfortunately just simply can't make their mortgage payment, but wants to avoid foreclosure. So loss mitigation is that system of helping borrowers who just can't make their mortgage payment, avoid foreclosure through workouts that are available. Now, there are arguments that loss mitigation is only there to help the investors or the government minimize loss. That is one role, but I always like to push back that a lot of these systems, the federal programs that we're talking about, it is not just about minimizing loss to the investor or the government, but it is also about preserving home ownership. All of these part of the system. These are all the goals, and what do we get to do that? So again, as you can see, this is separate from claims you may have to knock down amounts owed. This is not that. This is, though it can involve that if they do things wrong, but this is to help borrowers who are behind, that are built in because of this recognition that avoiding foreclosure can be good for the borrower, it can be good for the investor, and it can be good for the government actor as well. That is why we have these programs, and why it's a little different than other types of areas of law where things aren't necessarily built right in. So how do you do this? What are the types of options, and how does this work? Well, we have another concept which is called a waterfall, and sometimes they're at waterfall. This is just the metaphor that we have. The waterfall is sort of, what are the steps involved to analyze what options are appropriate for the borrower? So it's really the ordering of particular type of options. In other words, what you don't have is a borrower just saying generally, this is exactly what I need, and give it to me. I need a 0% interest loan, and I need it to be cut in half, right? If you have litigation, if you have claims involved, if the servicer has done something wrong, maybe you get to do that, but we're not talking about that here. What we're talking about are, how are these systems that are built into some of these loans, how are they ordered? And that is the waterfall. And what the waterfall does is say, and again, these waterfalls are done at the investor level. These are the steps we think you, servicer, should do, and in the order in which you should do them in order to see if we can prevent a foreclosure. And so they can be very different. Some are based entirely on what the borrower's income is. You shoot the borrower's income into a form and it would tell, and then the waterfall will tell you this is the option that's best based on what we've got. Sometimes we now have systems that are less about the borrower's income and more about the difference between whether they can just afford the payment they have or whether there is payment relief available that's not really based on income, but based on the information in the servicer's file. Those are different types of ways to see if you can help the borrower. But again, they are what we just generally classify as waterfalls, which are the order in which these options are considered as determined by the investor. So for the most part, these options are divided into home retention options and property disposition options. We think there is a path for you to keep the home, or we think there is nothing you can do. And here are some non-foreclosure options that you may have: short sale, deed in lieu. We're not going to get into those. We're going to focus on retention, but it's just good to know that there are some there. So loss mitigation, the system for helping avoid losses, both for the homeowner, the government, and the investor. And then waterfall, how do we order those options? And we do that generally at the investor level. So then what fills in the waterfall? What are the component parts? What are the tools that are considered? And so this is where the particulars, again, depend on the investor, but we have some general themes that are worth pulling out so that you understand. And again, you take these, understanding these concepts will then help you understand what types of things are available when you're reading a waterfall or looking at the book. The first thing is forbearance. And generally speaking, forbearance is an agreement to temporarily pause the obligation to make payments. I, borrower, have a disaster situation or some other hardship, and I can't make the payment. I need to pause my obligation. And then there are different rules of how long that payment can go. The key, number one thing to understand here that you have to drill in your brain: forbearance is not forgiveness. Forbearance does not mean forgiveness. So to get out of the closure, to avoid the problem, you then have to reach one of these other plans that we're going to talk about to bring back current the loan. Forbearance then causes the borrower to have a growing amount of money owed. It says, we're not going to pursue you in foreclosure for that time, but you, borrower, are going to have to figure this out. And this is where the risk is involved, because we have seen borrowers access forbearance, and then for some reason, maybe there's problems with the waterfall, maybe there's something else, the borrower is unable to bring the loan current even after forbearance. So this is, like I said, there is hard guarantees. There are times where you're going to have to figure out tools to enforce rules. Also understanding upfront what the options are at the end is really important. This is why forbearance is an important tool, but it is crucial to understand. It does not lead to forgiveness. You have to have some plan at the end to bring it current, and that can be rocky on occasion. depending on what tools are actually available. So key to know. Now, because we don't make things easy on ourselves in this space, there's another meaning of forbearance. Sorry, I didn't decide this, but there just is. There's another way we use forbearance, and I think you can think about one as forbearance plans and one about forbearance of amounts owed. So the first way we use it, we just described, which are forbearance plans, temporary pauses on payments in order to give borrower time because the borrower couldn't make their payment. And then we figure out something at the end of forbearance to bring it current, forbearance plans. We can also talk about forbearing parts of the loan as the solution to bring it current. We can talk about moving amounts owed. This is often called to the back of the loan and then restart payments. And what we're talking about there is removing amounts out of arrears, out of past due, and into 0% interest balances that become balloons at the end of the loan. We are forbearing payments until the end. That is a home retention option. That is a way to bring the loan current. It is, in some ways, it makes sense that we have this word used in two slightly different ways because both are delaying. But in the first, it is temporary and we don't have a plan at the end. We need to come up with one. In this second, we mean in order to bring the loan current, we're moving some of your amounts and we're putting them at 0% interest. When this is used, how this is available is all part of investor waterfalls. That is what we're talking about when we're talking about investor restrictions and waterfalls. The waterfalls tell you when you get to use this sort of thing. Now, again, important to know, even in this, we just have had little appetite in this policy space to just simply cancel amounts owed. There's just been little appetite for that. So that's where, instead of where you think you might just cancel something, especially when someone has a hardship or someone is really underwater, meaning they owe a lot more than their home is worth, but instead, we just do not have a lot of forgiveness of loans. And instead, we do forbearance, which is moving a big portion of the loan or some portion of the loan from interest bearing or from arrears to the end at 0% interest. There are benefits to that. Some of that depends on the particular math, but we don't have a lot of forgiveness around. So then when we think about some of the types of options that we're talking about, this movement and this structure of how to bring them current. One of the types of options, we're moving from short-term and transitioning into ways to actually bring the loan current. Fannie Mae and Freddie Mac have a deferral program. It is short but longer for disasters. So this is the type of forbearance we were talking about, where you take amounts owed and you move it to the end. So that's a deferral, which is but that is a Fannie Mae and Freddie Mac flavor of that. Now there's also, it can be done in what we're going to talk about later with a loan modification, but now we're talking about a deferral as one of these short-term options for Fannie Mae and Freddie Mac that allow the borrower to bring the loan current. So not the first type of plan, but Fannie Mae and Freddie Mac have one that allows the borrower to bring the loan current, and that is called a deferral. The biggest other one to know the type of system is FHA's partial claim program. Many folks who fall behind on their mortgages have FHA insured mortgages. And again, we're talking about what are the type of tools available. And the probably most complicated one in terms of how much actual documentation you get comes from FHA's partial claim program. And it is a very flexible tool that is used in all sorts of different ways. What it involves is we've got someone who's behind, and the way to help them is by FHA giving a 0% interest loan to that borrower to help deal with these arrears. It is called a partial claim because remember, FHA is an insurance provider and they are paying a claim to the servicer owner of the loan in order to bring the loan current, but then the borrower still owes the money at the end of the loan at 0% interest. So it's not, again, forgiven, but it is a good deal generally often for the borrower because at 0% interest, but they still owe it at the end, and that is the key thing to know. So again, partial claim is connected to how the program operates. FHA insures private lenders, and so the claim is paid by FHA to the person the borrower owed, but then the borrower owes the money still. And that is key. They don't make monthly payments on it. They don't have to. That is the key. So this partial claim is part of the stuff that FHA uses to bring loans current. How it is used is determined by the waterfall. The key for helping borrowers and why you need to understand how this works is that they have to sign a second loan payable to HUD. So you get people who think this seems like a scam. Why do I owe extra money? It's because they're behind and the partial claim is part of the tool that brings them current, but now they have to sign another loan and they have two loans, one accruing interest, which is the loan they had, which they are bringing current, and one not. This can be complicated for people and is part of the good thing you are doing for them. That is why it is crucial to have you, because a partial claim it can be crucial. It can be a very important tool, but can be very confusing. So it can be flexible, and it's actually gotten more flexible. It can be used to simply cover past due amounts. It may also be used to decrease the borrower's unpaid principal balance to make the mortgage payment more affordable. Sometimes it can be used for both. That's why it's worth pointing out specifically. But again, how that happens, when the partial claim is used, when the deferral is used, all of that, what the particulars are, depends on the waterfall. The waterfall is the guide, and the deferral and forbearance, like we talked about in a second, and the partial claim are the tools that are used. So there is one more tool, and then I'm going to pass it to Lynn here, that you need to understand. And that is kind of the primary one that has been used, and that is loan modification. So partial claim, we're talking about extra money from HUD being input in the system and then dealt with at the end. That is different, at least conceptually, than actually changing the financial terms of the loan in order to bring it current. So, and that's what a modification is. So the loan, when you got it, it has a balance it has the amount of months left over, and it has an interest rate. It has these fundamental terms, but when you fall behind, you get amounts owed, and then you have to deal with the arrears. But if what we're trying to do is make the payment affordable, maybe what we're going to do is change some of the other terms in order to make it affordable, and that can be the remaining amount of months owed. Maybe it's the interest rate, but from all of those terms, you generate what the monthly payment is. Monthly payment is basically a function of how much is owed, how much interest rate is, and what number of months are available. There's a separate part, escrow. Escrow is the money you collect and send out to third parties. We put that kind of over here for now, for the most part. But the term of the loan, the monthly payment, the terms of the loan and the monthly payment that's generated is a function of the balance, the rate, and the term. So maybe in order to bring this loan current and maybe provide payment relief when the borrower needs it, we're going to adjust these terms and maybe also bring in partial claim to reduce the balance or to cover arrears if it's an FHA insured loan. So, and again, those arrears are what you have to deal with. You are in this boat because the borrower couldn't make payments, and now we are trying to figure out what to do with the arrears. And arrears can include a lot of things, and some things the lender should charge, and some things they put in there that they shouldn't. That's part of the advocacy. But just in general, the arrears are what you're trying to deal with, and why you are thinking about, and why these waterfalls consider modification of the loan. So when you're pointed to a modification, you are generally adjusting multiple terms. So when the waterfall says modify, what they're thinking about multiple things, because what we've found and what these waterfalls often kind of turn on is that payment relief, reduction of payments are really important to actually make this plan work. Well, if you just add money to the amount owed and change nothing else, then you're not going to have payment relief. You're not going to have payment reduction. You're going to have payment increase. So often are looking for is, can you change some of the other terms, the payment amount of months still available. So the number of months that you can make payments on, or the rate, can you change those to make this affordable? And so that is what the modification waterfalls often look at. There is a big caveat though. It's not always just interest rate down. In some of these, in fact, because we're in a particular environment where the market rate is high and people's rates are low, interest rate reductions may not be available. Those rate reductions may have been available 2 years ago, but are now different because the market's conditions are different. So this is my last sort of pitch here. We have a lot of materials on this. Here's some of the materials we have at NCLC. There is a lot you can do, but there's also a lot to know and kind of stay on top of. So we try to stay very on top of what's available and how the options have changed. But to even kind of know that, I think it is just really crucial to understand investors make the decisions on what types of options are available, and you can identify those. Servicers are who you go through. The types of options are the ones we talked about. The particular things that are available entirely depend on those investor waterfalls. They say, what types of things? Is there a partial claim available? Can you have a rate reduction, or are you stuck with the rate? Can you extend the term of the loan to make there be more months available to pay it off over? All those things are determined at the investor level. This is really hard, and your assistance is incredibly important. Housing counselors, attorneys who do this, it is incredibly important because if it's complicated for you, it's even more complicated for them. We're really trying here to provide some help for you. And I put my email in the chat before. I would encourage you to reach out if you're trying to work on some of these with people. Again, we don't represent homeowners directly for the most part, but we do consult with attorneys who are helping homeowners. I'm here to help you with that. I hope some of this basic information was good. And now I'm going to pass it, I believe, to Lynn to go through some of the things you do in Florida. Lynn, the floor is yours, and you can tell me when to advance your slides.
I sure do appreciate that. And I really do appreciate all of this information. This is really complicated stuff. And I think the way that you presented it today really made it seem a lot more clear to me, and I'm sure everyone else. So what I'm going to talk about is just the basics of disaster assistance, how it's handled in court in Florida, just a few slides, and we would like to have questions and answers at the end. If people have questions that have been too complicated or long to put in the Q&A, we might be able to discuss them then. So with that said, so we are in the series, or Kathy is putting together the series. Going to have someone from the Attorney General's office speak an entire session on what disaster programs the Attorney General has and the different laws that the Attorney General focuses on pre, during, and after disasters and that sort of thing. Later on, probably next month, there will be more detailed information on FEMA and what it does. So what I'm providing today is just a very basic overview of the resources available in Florida. I think most of you probably are already familiar with these. Starting out with the very basics, there are two different types of declarations, an emergency declaration and a disaster declaration. And the second one is when all of the relief, rental assistance, home repair, etc., accessibility needs, all of that sort of thing is triggered when a disaster declaration has been made. You can advance. And so you can just go to FEMA, www.fema.gov disasters to look at any of the declarations. And if you could forward, I have two just sample landing pages for Ian and Helene in the next two slides. And yes, so for Helene, I'll show you this. By the time I pulled it down, was the disaster declaration had passed. But if it hadn't, you would be able to, in the darker area at the bottom, be able to get all sorts of information through drop downs, as well as the quick links for different types of resources and how-tos, FAQs, all sorts of information at the federal FEMA website. If you could please advance. So just to throw this in, because we know that there were several huge storms last year going all the way up into Asheville, and certainly many in Florida that impacted so many people. But at any rate, somehow politics became involved in both rescue efforts. And I did note that our Attorney General did sue FEMA because there was a whistleblower who worked with FEMA who indicated that they were advised to skip homes with Trump signs in the yard. I wasn't able to find the how the lawsuit is moved. It was filed as an emergency lawsuit, and they wanted to fast track it. Don't know how it's resolved, but there was some animosity, I think, among the state and providers as a result of the statements of the whistleblower. Next slide, please. So Florida has the Division of Emergency Management Disaster Response. You can get there at floridadisaster.org. Again, all sorts of resources. You'll get these slides, and so you'll have the information available to you. There's a legal hotline. The bar usually establishes something. 211 is always a good resource, Red Cross, and then others. Please advance. The Hope Line is a resource that seems to put businesses with people that need help and other types of professionals with people who need help. It seems somewhat, well, I don't want to say it's similar to 211, but it is a program that is highly recommended by the DeSantis family, according to their website. 211 has historically been all around the state, and during COVID, they were operational, and heard all of tales of all of the difficulties they had to go through to stay operational, and they do the same thing during other types of disasters as well. There is some information here on a link where one can go to for find open shelters as well. And the next slide, please. So what I've done here is I've gone to the FEMA website, and they explain at the FEMA website what a FEMA hold is. And a FEMA hold in general, I know there's 67 different ways of handling foreclosure cases in Florida. So I'm just going to go based on what I'm familiar with in Duval. Because so many of us work with plaintiff attorneys from very large firms on the other side, I suspect practices are very similar in other parts of the state. But what you see in the slide is a cut and paste from the FEMA website, and I added in red what I see really happening in Florida. So in Florida courts and the process. Just generally speaking, we all know if there's a hurricane anywhere in Florida, then there's going to be some pause in some types of foreclosures in Duval County. Duval County was not affected nearly as significantly as all of the other counties that felt the brunt of Ian, Helene, Milton, and other storms. But in our cases, our clients still get the benefit of the FEMA hold because there was a disaster declaration. I don't know that that's exactly what FEMA anticipated, but that's what happens. FEMA, according to FEMA, it's the foreclosure moratorium, which is the FEMA hold, is a temporary suspension of foreclosure proceedings for FA insured loans. So we're not talking, Stephen talked about a lot of different types of loans, but this is focusing on FHA in areas declared natural disaster zones by the President of the United States. So when the plaintiff will raise that they have been advised by their servicer client that the file is on a FEMA hold, then the attorney just goes to foreclosure court and tells the court that the case has to be put on hold because their client's telling them to do so. It's been my experience that most of the foreclosure judges in Florida, that we had a separate court of senior judges, and so that's all they did was foreclosure litigation. And so I never attended a hearing where a FEMA hold was requested by the plaintiff just to put the case on hold for several months or until. I never heard anybody ask, well, was the home affected by the storm? Is the home in the area designated as the natural disaster area? It just was it's something that's basically rubber stamped. So if there's a storm, we know there's going to be a break in litigation for some of the cases, and we know that's just going to be a given because it's not going to be challenged. And it's also been my experience that the concept of FA insured loans is interpreted relatively broadly by the servicers, because I've had the plaintiffs in cases tell the judge that the case has to be put on hold because of the FEMA hold, and it's conventional loan. So not a lot of digging takes place into whether or not the loan is appropriate. And I guess I keep my mouth shut unless it's in a case I'm affirmatively pushing. If it's going to benefit my client to have a small break while we're working on loss mitigation or other ways to resolve the case. And if it's a heavily litigated case, then we don't get any benefit from the FEMA hold, but in loss mitigation cases, I think we do. So FEMA indicates who the hold applies to. And it does say typically applies to FHA insured loans, and the property must be directly affected by the disaster, not just located in the disaster area. So I guess directly affected is also very broadly interpreted. In Duval County, we had the senior judges handling all the cases. Now our cases have been moved over to the circuit court, where the non-senior judges, the judges who are handling all other types of civil cases, are hearing the cases. So I did attend a hearing the other day. It was the first time this ever happened but it was with a circuit court, not retired judge. And so the plaintiff said, Your Honor, we need to put this reverse mortgage foreclosure on hold because our client has directed us that the property is under a FEMA hold. And so the judge said, we live in Jacksonville. How was the property affected by it was the latest hurricane? Was the property affected? The plaintiff's attorney didn't have an answer. And then she asked, well, why should I put the case on hold if the property didn't sustain any damage in the storm? And the attorney didn't have an answer for that either. And so the judge denied the request to put the case on hold for the FEMA hold. So we may start, maybe everybody has had that experience already where the judges are really saying, okay, was it directly affected if it was in the disaster zone declaration area? Next slide, please. So the FEMA hold, according to FEMA, usually lasts for 90 days, but can be extended. In my experience, the moratorium ends whenever the servicers say it ends. Generally, well more than 90 days has been my experience, particularly if it's a firm that handles a lot of cases. It can take a while for them to remember to get back to that case. We do get some judges who get irritated if there's not a defined time for the end of the hold, and so sometimes the hold will be more like the 90 days. But I find it, the concept of FEMA holds, who it applies to, and the duration is sort of a loosely defined concept. Again, they mentioned from FEMA that it has to be, your property has to be directly affected and or have your financial ability to pay your mortgage debt directly or substantially affected by the disaster. That's, I guess, pretty self-evident. If somebody's property is directly affected, there's always going to be a financial issue. So FEMA's role, of course, we know, and it provides HUD's role, but the one thing that we do need to focus on, I have contact your lender early and often, and that should have read call your servicer early and often, or call the servicer's attorney early and often. Because you want to make sure that you are considered in the types of relief that Stephen has gone over. Next slide, please. So most of us have heard of SHIP in all sorts of capacities, because this is the agency that is going to provide money, funds to the local governments to provide money to their homeowners for repairs caused due to damages caused by the event, or provide housing opportunities for those whose homes are uninhabitable, just for temporary purposes and rental. And they can also cover the cost of having debris moved. Next slide, please. So the Florida Housing Finance Corporation administers SHIP. I think some of us have dealt with them in the context of other grants and opportunities for borrowers. There are eligibility limits relating to a person's income. The local governments have control over who gets the money in some respects. And so some of the governments will require occupancy for a period of a year, and the property has to be homesteaded in order to be considered for the SHIP assistance. They more oftentimes the actual homeowner is going to have to file a claim with their insurance company and apply for FEMA at the same time, generally speaking. Next slide, please. So the next two slides are the final slides, so be thinking of your questions if you have some. But these are some of the things that we don't necessarily have at the state level. Certainly we have protections provided at the federal level during disasters, and we were using them quite liberally during COVID. But these are some things that I think that we are missing in the state that would be helpful. Most of these things relate to giving the borrower and the servicer time to adjust from the disaster and the financial effects of the disaster, and explore the many options that are available to them based on the type of mortgage they have, as mentioned by Stephen. So these are basically things that would be on my wish list. We need a moratorium for initiating foreclosures, which we have had in the past, and for an extended period of time, for the length of the disaster declaration up to, but not limited to 1 year. So it's sort of the beginning of a lawsuit, in a lawsuit, and giving time to make payments. So there should also be a forbearance of any litigation that has been filed, and there needs to be a reasonable time, because I think we all remember from COVID, we had these moratorium and forbearance agreements and all sorts of things, and then all of a sudden, all of it stopped, and people needed if the issue stops on 1 month, they're not going to have a full monthly payment the next, more than likely. And even more unlikely is will they have all the reinstatement figure amount from all of the months that they didn't pay. So these types of protections we may have at different times at the federal level, but we really don't have anything of this significance in Florida. Other things would include no unsolicited bids on homes for amounts that would not equal the fair market value. Restrictions on foreclosure or auctions, because now, of course, they're all electronic and people don't have access to the resources they have to get online. And one thing that a lot of us have been working on lately are issues trying to resolve mortgages with people who are heirs or have title in an alternative way and need a little work to get title cleared, whether it be through probate, through litigation, through resolution of a family law matter. But titling issues can be a real sticking point when trying to work through these things, which is, I think, is why the time periods up at the top of the list should be longer. And just one more slide, please. And of course, no predatory lending on loans originated during any disaster declaration period of time. And that would mean 1% over the prime rate. So we really do appreciate, I know this has been a lot of information. I was taking a lot of notes during Stephen's presentation and look forward to using those. Any questions? Stephen, is there anything else that you would like to add before we start answering questions?
No, I'd like to hear if there are any questions or whatever, however we can have this. So I thought that was great. And no, I'll pass it back to Jorge.
I don't see any questions in the chat or in the Q&A. If anybody prefers and if they want to raise their hand and come off mute, if that makes it easier, go ahead and do that and I'll bring you off mute. In the meantime, I'm going to drop the CLE code here for everybody to have it. It's here in the chat. The code is 2503794N. I also dropped the link to the materials where we have the slides that were used today. And I also have a Google document. I'm gonna turn it into a Word document as well, where I've been dropping a lot of these links that we've been sharing. Steve mentioned that free chapter 12. It's an amazing resource. So have it bookmarked. You know, that's one of those resources that you want to make sure you bookmark. And with all of those NCLC links that I listed, if you look at their listservs, they have a lot of resources. They had a lot of topics. Steve is in these meetings all the time and these conversations all the time, and that's why I was like, I need to get Steve to come talk to us. So I'm glad that worked out. So make sure to sign up for all of those listservs. They're great. You know, you have the Disaster Umbrella Group, which is a great way to monitor what's happening here locally in Florida, and we can also look at what's happening at a national level. So I'm waiting to see if there's any other additional questions. I don't see any for now.
I'll say one.
So
I'll say one other thing that's sort of a resources slash related to this. So one thing that is very challenging in what we talked about is dealing with problem solving when you think the borrower should get something and the borrower does not get the thing. And it is challenging in many ways. Typically, we, in addition to some of the things we're going to talk about, we talk about escalating within the government investor. That's challenging now because of potential job cuts, just other issues. It is hard to deal with that right now, maybe. However, in our materials, we have discussions about rules under the Real Estate Settlement Procedures Act, RESPA, and qualified written requests, notices of error, and requests for information. That is an entire topic that we are not going to be able to cover today. But I do think, and we have some chapters on that, but I think if you are building from what we've talked about, which are investors and how to identify what options are available through waterfalls, some of the next things you may want to look at are through some of these rights from RESPA, what are ways to troubleshoot and problem solve. And so I would suggest looking at chapter 3 in our mortgage servicing book. I will also plug that we are having a mortgage conference. It is about as far from Florida this time as it can be. It's not always as far, but this year it's going to be in Los Angeles. I'm going to put the link for that. We will be talking about not only some of the meat of what we were of investor rules, but some of the strategies for problem solving. So you don't have to go to the, recommend the mortgage conference for folks who can attend. But also you can look at chapter 3 of the mortgage servicing book. Lynn is also someone who is very good at problem solving and has been in that space before. So just wanted to raise that up. And I'm going to put the link to the mortgage conference here in the chat. Lynn, what would you say about troubleshooting? And do you have anything to add about RESPA or troubleshooting?
No, I mean, RESPA has been an incredible tool that we really use a lot in our practice. We're very fortunate to have in-house housing counselors working with us so that they can help us, really spot and help work up the RESPA issues, and it also works to help get information too. Don't take me wrong, but we also find having that close relationship with the housing counselors and our office, we pick up a lot of errors, a lot of issues of non communication. So yeah, was thrilled.
Yeah, so that's just the part of this that I think is a crucial piece of the tool bag or part of the toolbox is not just knowing who the investor is, knowing what options I think the problem solving part. And we have plenty of, that is an entire other session. We simply can't go through all of that here, but we do have materials about that I think could be useful.
Probably hear about it in LA, right?
And hear about it, you will hear a lot about it in LA if you can come.
Yeah, these NCLC conferences are highly recommended. We have 3 a year, Steve?
So we have the spring training, which is NCLC NACA spring training, which is coming up also in Long Beach, California this year. There will be a track on renters' rights that I think can be important, but also covering the Fair Credit Reporting Act and Fair Debt Collection Practices Act, solar, other things. And then we have the mortgage conference in June, and then our consumer rights litigation conference, which is sort of the catch-all everything. It is in DC. I know that. And I believe it is I can't remember if it's in October or November. I'm going to look that up right now. It is in November. It is in November in Washington, D.C. And here are the links to the conferences.
Thanks for sharing. I'll make sure to include these links and the resources materials as well. So I don't think I see any questions. With all that said, I wanted to thank everybody for joining us here today for our first session of this Consumer and Disaster Law webinar series. A big thank you to our speakers, Steve and Lynn, for sharing such valuable insights and practical strategies to support Florida homeowners in the wake of a disaster. We are really grateful for your time, expertise, and continued commitment to this work. We'd also like to thank Kathy Greenwald and our partners at Legal Services of North Florida, the Disaster Umbrella Group, and also the Public Interest Law section for helping putting this series together. So before we go, just some quick last-minute reminders. I will send out an email within 24 hours with links to everything, to the materials. It's going to have the CLE code. It's going to have the recording. We will also be posting it on YouTube with links to everything as well. And the next session of the training is happening next Friday, which is going to focus on renters' rights during and after a disaster. So the materials that I'm going to send will include links for you to register for that webinar if you haven't done so yet. And then before I forget, I did want to do a quick plug since it's related to everything that we're discussing on the consumer protection unit or group. I don't remember what the actual name is. It's TPU, and we have our monthly call. I know we don't have one for April because it falls in a holiday, but we do have some really exciting calls planned for May and June. So Lynn, if you want to do a quick plug about that monthly call for the group.
Sure. It's we've had a couple, and it's been really nice. We're talking about door-to-door home improvement scams, anything to do with finance, sales and finance, and relating to any type of improvement on a home. And so we talk about solar issues. We're gonna get into PACE at some point, but we're mainly focusing on just problems that people are having with their homes. And in connection with that, we are finding two things that we're hoping to address in the next two trainings. We are finding that a lot of the documents that are utilized in these transactions are e-signed. And so I've been communicating with Margot Saunders at NCLC also because she's forgotten more about e-signing than I'll ever know. And so she agreed to provide a very quick intro relating to e-signing at our May 16 meeting. And also in our June meeting, June the 20th, Catherine Hansen is going to be speaking to us about representing people who are disabled, making sure that we are giving them agency, making sure that they are being properly represented in court, and that we're going through all of the proper legal steps with respect to addressing powers of attorney and how they are treated differently than actual guardianships, and just making sure that when we represent a disabled person, that they are the client and their thoughts and wishes are being heard. So we're very excited about those next two programs.
All right, so I guess we're at time. I wanted to thank everybody else again and have a great rest of your day and enjoy your weekend.
Thanks, everyone.
Thanks to you, Lynn and Stephen. Bye-bye.